Good evening.
Good evening.
Thank you. One person. Good evening. My name is Deborah Kaplan, and I'm the administrative judge here in New York County Supreme Court Civil Term. And it is really a great pleasure to welcome you. Thank you for joining us this evening for this very special flagship event commemorating the 45th anniversary of two New York Court of Appeals rulings issued in July 1973, In re Thom and In re Kimball. And these landmark rulings are fittingly recognized in the name of our program tonight, which is July 3rd, 1973, the day the Court of Appeals made Pride possible in New York. I want to start by expressing my gratitude to the Richard C. Failla LGBTQ Commission of the New York Courts for their hard work and for making this wonderful program possible. I'm grateful as well to our own Chief Clerk here in Supreme Court, John Warner, Michelle Gonsiecki, our Head of Facilities, and their administrative staff for their efforts in putting together and planning this event. And I would be woefully remiss if I did not take a moment to thank our biggest supporters, our Chief Judge, Janet DiFiore, our Chief Administrative Judge, Lawrence Marks, and our Deputy Chief Administrative Judge, George Silver. And their unwavering support and commitment to our court generally, and in particular to this program, is extraordinary and deeply appreciated. I also want to recognize the efforts of the Commission co-chairs, the Honorable Marcy Khan and Joanne Winslow, as well as Executive Director Matthew Skinner. And finally, I want to thank all of our speakers for being here and say it is an honor to have you here in our court to address us, and it's really an illustrious group. And for some of us, 1973 might seem like a really long time ago, eons ago, and yesterday in the minds of others, and it surely was a transformative year for the rights of lesbian and gay people in New York. And it was obviously the year that Harris L. Kimball's denial of admission to the New York State Bar was reversed. As many of you know, he had passed the New York State Bar exam, and the Committee on Character and Fitness reported that he possessed the requisite character and fitness for an attorney at law, quote, notwithstanding the admission of the applicant to being homosexual and having engaged in homosexual acts, end quote. However, the Appellate Division's Second Department denied his application for admission, and on appeal, the Court of Appeals reversed and remitted the matter back to the Appellate Division for reconsideration of his application for admission to the bar, with an instruction regarding the notion that homosexuality was disqualifying. It was also the year of 1973 that the Court of Appeals reversed the Appellate Division First Department and recognized the right of Lambda Legal to exist as a nonprofit organization, the nation's first legal organization dedicated to achieving full recognition of the civil rights of LGBT people. And Lambda's founder, William Thom, was, and I think you'll all agree, remains a force to be reckoned with. He went on to become a civil court judge and the first openly gay appointed judge in New York, and was quoted in the Times as saying, "I think very shortly there are going to be some more openly gay people serving on the bench of the city of New York," and that happily turned out to be true. 3 years later, in 1988, Richard Failla became the first openly gay person to be elected to the New York State Supreme Court, and our Associate Justice in the Appellate Division First Department, Rosalind Richter, who was Executive Director of Lambda Legal, ascended to the bench here in 1990. And while it took longer than many might have hoped, we now have our first openly gay judge of the Court of Appeals, our highest court, the incredible Justice Paul Feinman. And it continues to get brighter because following the confirmation of Justice Feinman, Justice Elizabeth Gary became the presiding justice of the Appellate Division Third Department, making her the first LGBTQ person to serve as a presiding justice in any department of our 4 states appellate division. So, we've come a long way in protecting the rights of gay, bisexual, respect and equal rights to which every human being is entitled. Please welcome Associate Justice of the Appellate Division, Marcy Thom.
Thank you, Justice Kaplan, and thanks to everyone for coming out tonight for this wonderful, historic, and proud celebration. On behalf of the Failla Commission, I would like to thank our co-sponsors, Legal, Lambda Legal, the New York Association of LGBT Judges, the Gender Fairness Committee of the New York County Supreme Court Civil Term, the Historical Society of the New York Courts, and the Gay Straight Alliance. I particularly would like to thank Justice Kaplan and Chief Clerk John Werner for hosting us here in their beautiful home today. As Justice Kaplan said, the focus today is on two landmark judicial rulings which transformed the lives of LGBTQ people under the law. To those of us who remember when there were no openly LGBT law students, I was in law school before Kimball, thank you, and I can tell you it was quite anxiety-producing. And there were no out gay lawyers, and there were no public interest law firms committed to securing the rights of LGBT people. Acknowledging these judicial milestones is a poignant reminder of what the old normal was. The pace of the changes that we have witnessed during the course of our own lifetimes, like decriminalization of consensual adult sexual conduct in the Onofre case in 1980, and of course, marriage equality, has been nothing short of remarkable. We gather today not only to recall and celebrate these historic rulings and teach them to the next generation, but to recognize the courage and leadership of our honoree, Judge William Thom, in breaking down these barriers to equality. Judge Thom was a mentor of mine when I first joined the bench in 1987, and all of us who followed him onto the bench or aspire to do so owe him a debt of gratitude. We also acknowledge tonight, I'm sure they won't say it, but we really should, acknowledge the groundbreaking work of our other speakers, who each in their own way stood up when it was not easy to do so, and insisted on equality under the law, and have made a difference for all who have followed. Although we live in very challenging and troubling times, by remembering this history and what we have overcome, we will be better able to protect and preserve the rights of all going forward. Thank you very much, and enjoy the program.
Hi, everybody. I want to thank everybody for coming out tonight. I know we're competing with many other events, and thank you for giving us a little bit of your time. Tonight's event was really a labor of love. I had seen these case names, over the years in different documents and whatnot. And I finally, earlier this year, had the chance to really, read them and think about them. And I thought, what a terrific event this would be if we can pull it together. And I was talking to Alex before I started here, and I was saying, most people in our generation, I don't think, know this story at all. And I think it's a really good time for us to be thinking about this story and what it means and what sort of a renewal of the spirit of the folks we're going to celebrate tonight. I just want to highlight two other folks that are here. In fact, Michael Lavery, who's in the second row over here, was one of the two other incorporators with Bill of one of the three folks that had their names on the incorporation papers for Lambda Legal. And sitting behind him is Nick Russo, who was on the original board of 6 people on the Lambda Legal board. And they're also heroes that we're celebrating here tonight. There's been a really robust public debate happening the last few weeks, as the people in this room surely know, about the relationship between the First Amendment and the LGBT community. But the interesting thing is these were really the blockbuster First Amendment cases of their day. And you can see sort of the reprints of the very short opinions in the program, but there's so much going on beneath the surface of those very short opinions. And I'm hoping we can unpack a little bit for you tonight what was going on behind the scenes and share the really awesome story behind the speakers tonight. We did find when we were doing the research for tonight's event that Harris Kimball died in 2014, unfortunately. So he's not here tonight to share his sort of personal perspective on what happened 45 years ago. But I'm delighted my friend Art Leonard is gonna tell us a lot more about that case and that individual. But first up, I want to turn over the microphone to Bill Thom, our principal speaker tonight, to tell his amazing story of the events that led to the decision in his case.
Thank you, Matt, and thank you, Judge Kahn, for your very nice words. I'm sorry I have to start with an apology, and that is after I make my remarks, I have something that I have to go to, so I won't be hearing the other speakers. I'm very happy to see that this is being recorded, and I'll be able to hear their remarks on a later occasion. I was asked to describe how Lambda Legal came into existence. And in order to do that, especially since we have a fair amount of people in the audience this evening who are not 77 years of age, I think it's important to describe the background that Lambda was created to deal with. I arrived in New York City in the late 1960s, and at that time, being gay was officially a mental illness. In 49 of the 50 states and the District of Columbia, if gay people were involved in a romantic relationship, they were criminals. In the city of New York, gay bars were illegal. They existed, of course, but they only were able to exist because of corruption by the police department. The police department would, if payment was a little late or just to keep their hand in, would do sweeps of gay bars and other locations where gay people congregated. These mass arrests would then be treated in the court system by lawyers who jacked up their fees to very high levels, shared them with the police officers who referred clients to them, and it was basically a gigantic shakedown system. Some people who were caught up in these sweeps were so terrified that they would literally do anything to escape. And at that time, there was a famous case in which someone who was here in an undocumented status threw themselves out of a second-story window and were impaled on a fence. They managed to survive. Our political clout was zero. In fact, you might say it was almost minus zero, if there is such a thing, because we didn't have enough influence that the politicians even bothered to say no to us. They wouldn't let us in the door to even discuss our issues. Gay people also suffered from two other drawbacks, which were, I think, unique to our particular minority group. One is that most minorities, if they are of religious bent, can go to their religious or spiritual leaders and get comfort from the vicissitudes of life. But in our society, the Hebrew Bible, which has been adopted by the Christians as the Old Testament, has some pretty terrible things to say about gay relationships. So the chances that your rabbi or your pastor would be sympathetic to anti-gay discrimination in the late 60s and early 70s was very poor. But even more important than that was the most important ties for most people is their family. And in a family situation, you can do some pretty terrible things and expect your mother and father and brothers and sisters and uncles and aunts to still be in your corner. But when it came to homosexuality, it was a very, very up-in-the-air thing. Many, many gay people just assumed their families would disown them or worse. The first time I ever went to a meeting of the Gay Activist Alliance, there was a young man seated directly behind me. His arm was in a sling. And I found out that that day, or the day before, he had told his family that he was gay. The father had broken his arm on the spot and kicked him out into the street. And even in situations where physical violence wasn't in the picture, people stayed in the closet because they were very, very apprehensive as to how their family would react. Fortunately, I think we've come so far from that that most people now believe that they can be honest with their family about things of that sort. But the religious problem and the family problem seem to me to weigh very, very heavily on the despair that permeated large sections of our community. When I got involved in the gay civil rights movement as an attorney, I had to think about how can I best serve the community with the skill set that I have. I've often thought there are two kinds of innovators in this world. There's the type of innovator who causes people to see the world in a wholly different way, like an Albert Einstein, who turned the world of physics up on its head. But there's another type of innovator who sees something that, in retrospect, will seem perfectly obvious, but which nobody has come along and done yet. I think about a person like Henry Ford, who didn't invent the car, he didn't invent making cars, and he didn't invent the assembly line. But he came to the realization that if you put these things together, you're going to have a business that is a world beater. Well, when I looked at the situation in the late 60s and early 70s, I certainly was not the first person to get involved in gay civil rights. We'd had the Mattachine Society, we'd had the Daughters of Bilitis, we had the Gay Liberation Front, we had the Gay Activist Alliance. They had all set their cap to making the world a better place for gay people. And the idea of a legal defense and education fund was certainly not a new idea. The NAACP had come up with this at the very beginning of the 20th century, and other people had come to use this vehicle for other minority groups. But I came up with the idea that we should have one for the gay and lesbian community, and I went about setting out to create that very vehicle. Now, for those of you who are somewhat familiar with how corporations are formed, the usual procedure is just to come up with a certificate of incorporation, submit it to the Secretary of State, pay a fee, and you're in business. Well, at this time, there was an elaborate statutory and procedural framework that you had to comply with in order to get a legal defense and education fund off the ground. But nevertheless, I assumed that this would be basically automatic once all the procedural red tape had complied with. Among the things that I had to do was submit the incorporation to the Bar Associations of Bronx County, New York County, and the Association of the Bar of the City of New York. I had to go to the Department of Education and get their permission. And after having put all the paperwork together, I had to go to the Appellate Division and get their permission before I could submit the Certificate of Incorporation. Now, some of you may wonder, why did I call it the Lambda Legal Defense Fund? After all, most legal defense funds have in their name an identification of the beneficiaries: Asian American, Puerto Rican, a National Organization for Women, NAACP. If you know these organizations, you know who their beneficiaries are. But I wasn't setting out to benefit lambdas, whatever they may be. The reason I chose that name is because the Secretary of State of New York, liberal Northeast New York, had taken the position that if you put gay in the name of a corporation, he wouldn't accept it. That policy was eventually overturned, but I was eager to get started and to avoid a court fight. This proved to be a waste of energy because the court fight came anyway. Much to my surprise and dismay, the Appellate Division declined to accept the papers for incorporation. I was completely nonplussed because it was completely unexpected. I was not out in my law firm, and the Appellate Division decision made the front page of the Law Journal. Somewhat to my surprise, not one of the partners said boo about this front page decision, except one of the junior partners who stopped by my office and said, "I see you made the papers today." While I was wondering what I should do next, I was approached by the firm of Rabinowitz, Budin, and Standard, who wanted to get copies of my certificates of incorporation and supporting documents because they were mounting a challenge to the red tape that was being used in connection with establishing legal defense firms. Being bold as brass, young whippersnapper at the time, I asked them if they would be willing to take an appeal in my case for free. Somewhat to my surprise, they agreed to do it. They took the case up to the Court of Appeals, won it, and thanks to their efforts, Lambda Legal Defense came into existence. In the 45 years since that has happened, I can say that it has resulted in without doubt, the most significant thing that I have done in the public sphere by far. The women and men who have carried on after the 10 years that I spent with Lambda have made it not only the preeminent gay rights legal organization, but one of the preeminent rights organizations, period. And I'm very pleased that you'll be hearing a little later from Rachel Tiven, who is our new CEO. But their record of accomplishment is more than I could have ever hoped. So with that background, I want to turn the microphone back, I guess, to Matt, and to thank you all for coming.
We have a little plaque here to give to Bill to thank him for his huge contributions.
We're going to just read it to you. It says, the Richard C. Failla LGBTQ Commission of the New York Courts proudly recognizes William J. Thom for his courageous actions in the fight to incorporate Lambda Legal and trailblazing accomplishments as the first openly gay judge in New York, June 19, 2018.
So as you sort of heard in Bill's story, the appellate division, unfortunately, turned out to be the villain in this story. But ironically, one of its first employees, Justice Roz Richter, would later become the first openly gay judge at the appellate division First Department. And today, I believe Art Leonard has characterized the First Department as the gayest appellate court in the country. Justice Richter will now share share her story of how she first worked at Lambda.
So I was not on the appellate division, nor were any of my other lesbian and gay colleagues. And whether the decision would have been different, we'll leave it to you. So it really is an honor to be here tonight. But for Bill's bravery and Michael Lavery's willingness to hire me along with some other people, I might not be standing here today. I've been asked to say a few words about what it was like to be an out lesbian in the 1970s and 80s, and that's actually what I'm going to talk about. It's really hard to believe how many decades have passed. The world was totally different then. It is impossible to imagine, if you were not there, how different it was. I came out in college sometime late 1974, early 1975, it depends on how you count, as part of a wave of lesbian feminists who joined the lesbian and gay community by coming out in the feminist movement. The community then was entirely separate, in my mind, as I look back now. Lesbians and gay men lived very different lives. We had separate organizations, we had separate events, we had separate marches, and at times it felt like we spoke very different languages. There were no out lawyers that I knew about. I didn't hardly know any out professionals. I didn't know about Lambda, even though Lambda had been formed. But in college, I knew about a group called the Gay Academic Union, and I joined it along with another group called Lesbian Feminist Liberation. Those of you who know me can ask me what I was doing in a group called Lesbian Feminist Liberation, but there I was. The Gay Academic Union was for teachers and professors. I had no interest in being a teacher, but they were licensed professionals who were out, and they were the only group I could find that I thought, oh my God, I could have a career and I could be out. There were no out professors at Barnard, which now might be one of the gayest colleges in America. I recently talked with someone who attended Barnard and overlapped with me, but mostly was there a few years later. And she insisted in this conversation that there were out professors because the professors who were there who were lesbians came out later. But as we talked about it, we realized it simply was not true. There was no one on the faculty or administration who would talk about being gay publicly. And I was at Barnard when the lesbian student group formed, and I can't even remember if we had a faculty advisor, but if we did, they certainly weren't self-identifying. Law school was even less welcoming. I was very out in law school, but there simply were no role models. Today, I remain grateful for the women law professors, for the straight feminist law professors, who, just as at Barnard, provided a source of inspiration to me and encouraged me to become a lawyer, telling me I could fight for the causes that I believed in and still get admitted. I vaguely heard about Lambda sometime in my third year of law school. I sort of don't remember how. Because there weren't any LGBT student groups, there were no out professors, There were no seminars on LGBT issues, and there were certainly no law firms looking to diversify by recruiting at law schools looking for LGBT students. In fact, it was the complete opposite. Believe it or not, I was 24 years old when I became executive director of Lambda, and at that time I was its only full-time employee. I remark to the day why anyone took a chance on me is sort of an amazing thing, but I was willing to raise money, I was willing to be out, and I was sort of either fearless or foolish, or maybe a little bit of both. I arrived at Lambda, and frankly, my primary job was to answer the phone from panicked and hysterical clients, and a few more hysterical lawyers who weren't in New York City and didn't know how to help their gay clients. I realized that I had been living in a New York City lesbian bubble, because I got calls from people across the country who had lost their children simply because of their sexual orientation, or whose landlords told them one day they had to move out, or from gay men who were being arrested in New York City parks and public beaches simply for engaging in consensual sex in the middle of the night when there was no one around. It was only in December 1980, 6 months after I arrived at Lambda, that the New York Court of Appeals in People v. Onofre held that criminalization of consensual sodomy violated the federal Constitution. That case, in my mind, looking back, made a tremendous difference in people's lives, and Lambda was one of the amici in that case. I fondly tonight give credit and recall Margot Carl, who was Lambda's president, and frankly back then was one of the only lesbian role models, and who was responsible for my decision to stay out in the legal profession. The Onofre case, I believe, began a long process that took several more years, and perhaps still is going on, of altering people's perceptions of the risk of being out. Because even back then, even if you were never going to have sex on a Fire Island beach or engage in sex in the middle of the night in Central Park, gay people, and especially gay men, worried. People thought if they got arrested, that would be the end of their lives, and they stayed in the closet because of that fear. As the Kimball case showed, the consequences of a criminal arrest could be devastating, not just for lawyers, psychologists, teachers, psychiatrists, every licensed professional worried. And I remember that back then, you couldn't put Lambda's name, even though gay wasn't in it, on an envelope, because people were so afraid that their neighbors would think they were deviant, simply because there was a law about deviant sexual intercourse. 40 years later, the world looks very different, and the bench looks very different. And I suspect it's hard for some of you to understand the fear that existed back then. Some of that fear was real, and I don't want to minimize the consequences. There was no legal protection pretty much anywhere. But some of it, in my opinion, was self-imposed. I never hid my identity, and obviously my career turned out just fine. In fact, some people would say it turned out pretty great. I am certain, over the decades, there were jobs I did not get because I was out, and Lambda was on my resume. And I could tell you stories about the homophobic and stupid interview questions people asked, especially when I went to look for a job after having been at Lambda. But I still believe that by being out, I, and the many others in this room like me, we changed the world. We changed people's attitudes, and as my friend Evan Wolfson would say, we changed people's hearts and minds, because everyone today knows someone who is lesbian or gay. But I don't think it's over, and I urge you to remember that it is just as important today to be out, to be involved, and to speak up. It isn't easy. It isn't easy to be the one to say something when you hear an anti-gay comment in the courthouse, or to intervene in life when someone is being bullied. But I implore you to ask yourself, where would we be if Bill Thom and the other men who helped found Lambda had stayed silent and left it for someone else to take up the cause? If they had not been willing to put their name on a piece of paper and say, I'm associated with something gay. We all know if they had not been so willing, the world would be a very different place, and we might not even be able to have an event like this. Happy Pride.
Thank you so much, Justice Richter. Judge Feinman, you're up next.
Well, it's a tough act to follow, Judge Thom and Judge Richter, and I'm not even going to try to be nearly as substantive. But let me begin by wishing everybody a happy Gay Pride Month. And let me also begin by stating that it's a pleasure to be back here at 60 Center Street among so many of my court family, friends, and colleagues. I also want to thank my good friend Deborah Kaplan, the administrative judge here in New York County on the civil term, and New York County clerk Milton Tingling, as well as their dedicated staff for opening up their house to the Failla Commission for this program. So I bring you greetings, and I spoke to her earlier today, from the Chief Judge of the State of New York, the Honorable Janet DiFiore, who established the Failla Commission early in her tenure, and who is fully supportive of its mission statement that is outlined on the back of your program. She congratulates the Commission, its co-chairs, Justice Marcy Kahn and Joanne Winslow, its Executive Director, Matthew Skinner, and its members for organizing a slew, and I mean it's a slew, of varied and meaningful programs across the breadth of New York State to mark LGBTQ Pride Month. Obviously, as a member of the Court of Appeals now, I am particularly grateful to the Commission for having this program, which focuses on the role of the Court of Appeals and its role in laying the foundation for the use of the rule of law to advance the goal of an inclusive and just society that does not leave LGBTQ people on the outside looking in. As a side note, I want to thank, although she's up in Albany, the librarian Julianne Clayton, who I know made so many of the materials, such as the original briefs, the original certificates of incorporation. All of this stuff is archived up there in Albany, and she made that available to Matt and to all of us to look at, and it's, I mean, not only do you realize how far we've come in LGBTQ rights, but how far we've come in the technology. You know, nothing is handwritten the way it was in some of those documents anymore. Any event, unless you're getting it from a state prison. That was a side note. As Justice Kahn remarked earlier, we live in very challenging times, and there is discord, social unrest, and grave concern as to whether large swaths of the public still accept the basic precepts of our democratic system of government. And it's important that we as lawyers and judges remember that while ours is an imperfect society, and certainly the decision of the appellate division back in the early 70s, to my line of thinking, was an imperfect decision. It's our adherence to the rule of law that advances us to a more perfect union. And that's true even if it does so too slowly for our taste at times. And I think this has been a helpful exercise in looking backwards in order to gird ourselves for moving forward. because it reminds us, as Martin Luther King Jr. taught us, that the arc of history does bend towards justice. And this is true even if along the way there are setbacks, missteps, and masterpiece cakes that get left out in the rain. Okay, that joke didn't go over. You have to have been a Donna Summer fan from the 70s, and I see people out here who are too young to even know what I'm talking about. But it is Gay Pride Month, and I couldn't let it go without a disco reference. Sorry. So, but in all seriousness, in reflecting on our past, we do find the way forward. And I didn't actually prepare this, but Roz's remarks made me think about my own experience. And I'm just a few years younger than Roz, but just a few. But they were critical and critically different in this experience. So, Roz talked about her experience at Barnard. I was at Columbia a few years later. It was still all male. And there was, the gay people at Columbia that I was involved in, and there was lesbians at Barnard, and it was all very separate. But then by the time I got to law school in the years 1982 to 85, the AIDS crisis was in full-blown, horror. And I really think that was a critical point in the history of the LGBTQ movement in bringing some sense of unity and some sense of purpose for women and men acting collaboratively. And our lesbian sisters were there for us, the gay men, in that critical time period. And I have to say that it is true that when I was in law school, the particular law school I went to was in the Midwest, there was no LGBTQ group at the law school, so we started one. A friend of mine who later succumbed to AIDS and I did that, and it was a very, very interesting experience working collaboratively with other groups, whether it was the Latino Law Students Association or BALSA, the Black Law Students Association, to go through the whole funding process of how universities fund student groups. And one of the things that I remember, because I was reflecting on this as Roz was speaking, is that we had to not necessarily identify a list of names, but they wanted to know numbers, and some folks did want to know names to justify that, well, we're going to give you X dollars out of the student law school council funds. And one of the concerns is that there were a lot of people who still, and particularly with the stigma of AIDS being associated with, oh, if you're gay, you're probably going to have AIDS. That was the thinking. There was a lot of stigma, and folks did not. They still had a lot of fear, and this is, as I said, 82 to 85, so it's a little more forward in time. And yet we managed ultimately to get those funds and to go on to do very good work in getting the military, this is pre-Solomon Amendment, banned from recruiting at the law school. But that's all gone now with the Solomon Amendment. So that fear definitely lived on into the mid-'80s, and since we're doing this history lesson. And I do think the AIDS crisis, by forcing so many people, sometimes against their will, out of the closet, whether to their families or to their co-workers, by forcing them out of the closet, really began to change the way gay and lesbian people were perceived in this country. So now back to what I originally planned to say. That little sidebar is finished. Thursday is going to be 1 year since my Senate confirmation to the Court of Appeals. And it has been a whirlwind year. And I have to say that certainly when I was in law school back in the mid-'80s, early into mid-'80s, I never dared dream that I would someday be a judge, let alone one on the state's high court. But many of the individuals that you have heard from already and that you're going to continue to hear from set footprints that I could follow. And as a young lawyer, I had the honor and privilege of appearing in front of Dick Failla, in front of Mary Bednar, and in front of Justice Kahn in criminal court in arraignments. And as a newly minted judge in the late 90s, I had the pleasure of working with Judge Somberg and various associations, such as the New York State Association of LGBT Judges. And I think the current president of that group, Judge Farber, is here somewhere in the audience. And I also, through Michael, got involved in the International Association of LGBT Judges. That's this pin. And the current president is here from Philadelphia visiting us, Judge Anders. And I also had occasion through Legal to get to know Art Leonard, who is the founding member in his living room of what would later grow into Legal, the LGBT Bar Association of Greater New York. And that was also visionary Art. And my involvement in Legal was critical to my successful run for judicial office later in 1996. And that's this pin. So those are my pins, and I do have to say that both of those groups were very critical to my development as a lawyer and as a judge, and the members of those groups helped nurture and set a path forward. So those are early pioneers that blazed the trail, and I am grateful for their example of leadership, courage, and determination. And I did not forget Bill Thom, because there's always someone who is first. And I thank Bill Thom for having had the fortitude to be that person in terms of setting an example that LGBT people can be out and be judges. And I thank him obviously also for his vision along with Mr. Avery of creating Lambda and not giving up on the fight to incorporate it. The LGBTQ community is obviously forever in their debt. So, in speaking about the footprints that I follow, I think it follows that we have a duty to set a new set of footprints forward into the future. And I'm happy that I saw earlier this evening one of the Hank Henry interns who is present, Victor Tarantino. I saw him earlier. And the Hank Henry program, by the way, for those of you who are not familiar with it, is a program of the Lesbian and Gay Bar Association of Greater New York, in which interns who are law school, typically second year, law students who are typically second or first year law students, rotate through the chambers of various LGBTQ judges, and sometimes straight alliance judges too, and get a taste of what it is like to be a judge and to perhaps someday aspire to the bench themselves later in their career. And what I think was really, this is the first year, it's not the first year that I've served as a host judge, I've done that for years, but it's the first year that I served on the selection committee. And reading the essays, there were about 23 applicants this year, or perhaps even more. But in reading the essays, what you learn is we do, as Roz said, sometimes live in a New York City bubble. And it's important to remember that there are still a lot of very frightened people out there in other parts of the country. And given the tenor of the times, I see that fear only increasing. And so, to the extent that you can set an example. I implore you, as Roz said, to do so, and to set that set of footsteps forward, footprints rather. So we do have a long program, and I'm going to end there where I began, which is by wishing you all a happy and safe Pride. Take care.
Thank you so much, Judge Feinman. As I mentioned at the beginning, we discovered that Harris Kimball died in 2014, but we asked Professor Art Leonard to come up and talk about the Kimball case. I don't know anyone that may not have thought about it this way, but anyone that sort of took the Kimball case and ran with it more than Art Leonard did in terms of getting LGBT lawyers in New York City organized and active and coming together to work on things. Professor Art Leonard.
Thank you, Matt, and happy Pride, everybody. I'm here to tell you the tale of Harris Kimball, who was a courageous lawyer. He was practicing law in Orlando, Florida, in the mid-1950s, and he had a general practice, but he had a particular interest in civil rights at a time and place where that did not make him a popular figure with the local bar and authorities. He would bring civil rights lawsuits on behalf of people of color at a time when things were very segregated and very discriminatory. Responding to rumors that he might be gay, the local police set a trap for him, using a handsome military man to entice him into a compromising position on the beach at night, where he was arrested and subsequently charged with a violation of Florida's sodomy law, then a felony offense. Remember, this is 1955. Think back to the 1950s. Few of us were then alive, but I was. A mere toddler at the time, though. But at any rate, gay sex was illegal everywhere in the United States in the 1950s. And in almost every jurisdiction, it was a felony. And Harris Kimball was a member of the bar. And, you know, if a member of the bar is convicted of a felony, forget about remaining a member of the bar. And so what happened was he was charged and he just forfeited his bail and didn't show up, which they treated as a plea of no contest. So it was basically a conviction, and the Florida bar ran with it. They preferred charges against him. They held a hearing. They brought in the police and all the witnesses, and they concluded that he had, quote, committed an act contrary to good morals and the law of this state. And they recommended to the Florida Supreme Court that he be disbarred. The Florida Supreme Court adopted that recommendation in 1957. He eventually moved up here to New York. He was living upstate in Garrison, New York, and supporting himself doing other kinds of work. Although the Florida Supreme Court subsequently issued a decision that resulted in sodomy being downgraded to a misdemeanor in Florida. And he tried to follow up on that and see if he could get reinstated, but they wouldn't do it. But he decided to try here in New York because in the meantime, the New York legislature, in the course of adopting the model penal code here, they didn't go all the way. The model penal code recommended decriminalizing private consensual sex between adults. The New York legislature wasn't ready to do that in the 1970s, but they were willing to downgrade what they call deviant sexual intercourse into a misdemeanor. And you don't have automatic disbarment for a misdemeanor. So Harris Kimball decided to give it a try and see if he could get admitted. He had been away from practice so long, and there was no reciprocity anyway with Florida, so he had to take the New York bar exam first. And he did. He passed it. He was a good student. And he remembered a lot, I guess, from the old days when he used to practice law. This was already the 1970s. So he passed the New York State bar exam. He went before the Character and Fitness Committee for the Second Department. And they loved him. They thought he was terrific. They said, oh yeah, we just have this one problem. He was disbarred in Florida. And we think under New York law, if you've been discharged in another state, you can't be admitted here unless you get readmitted there. And of course, he had tried and he hadn't gotten readmitted in Florida. So they sent a report to the appellate division, and the appellate division, 5-judge panel, they all agreed that the Florida disbarment was not necessarily a bar to being admitted in New York. They said it's something to take into consideration, but it's not necessarily dispositive. But on the other hand, the court said, we still have a law against gay sex in New York. And he wants to be a lawyer, a member of the bar. And he was very upfront about the idea that he was a gay man, and he was going to engage in gay sex, and he was going to be violating the penal code, and he was not ashamed about that. And he said he didn't think that was a disqualification. As far as he was concerned, it had nothing to do with his ability to be a good lawyer. Unfortunately, a majority of that 5-judge panel disagreed with him. And they said, our legislature still considers consensual sodomy an act of deviant sexual intercourse, and as such a Class B misdemeanor. Accordingly, so long as this statute is in effect, homosexuality, which in its fulfillment usually entails commission of such a statutorily prescribed act, is a factor which could militate against the eligibility of an applicant for admission to the bar who proposed to pursue this way of life in disregard of the statute. So they were unhappy that he was very open about being a scofflaw and intended to continue in that course, even if they admitted him. They also pointed out that in the Florida disbarment proceedings, he had given several different versions of what happened on the beach that night. And they said, clearly, some of them are true, maybe, and some of them are false, but we have some trouble about giving false testimony in hearings. We think that's a problem, too. So that was the majority, but it was 3-2, and there were dissenters. And the dissenters said, first of all, we all agree, all 5 of us, that we are not required to give full faith and credit to the Florida Supreme Court disbarment decision. And they wrote, wholly apart from Florida's refusal of reciprocal courtesy, we cannot and should not blindly follow its disbarment holding. Because, as the majority admits, differing conditions in place, time, and social and moral climate may well dictate a different holding in New York today than was made in Florida in 1957, with respect to the applicant's fitness to practice law. But, they went on, to us, it seems clear that the social and moral climate in New York, and probably throughout the Western world, has in recent years changed dramatically with respect to homosexuality and consensual homosexual acts. Today, they are generally viewed as no more indicative of bad character than heterosexuality and consensual heterosexual acts. I think for 1972, that was a little optimistic. But at any rate, in our opinion, they said, an applicant for admission to the bar in New York in 1972 cannot be considered unfit or lacking the requisite character to practice law merely because he is an avowed homosexual. And we agree with the Character Committee, finding that this applicant is fit for admission to the bar. The dissenters were also willing to overlook the inconsistency in Kimball's testimony in the Florida disbarment proceedings. They pointed out, quote, his youth at the time of the disbarment proceeding, the nature of the charge against him, the social and moral climate then prevailing with respect to such acts, the predicament he was in, and what must have been his then distraught emotional and mental state. So they were willing to give him a pass on that. They insisted it's his present fitness and character that we are here considering. Well, Kimball appealed to the Court of Appeals. He was represented by Jeremiah Gutman, and an amicus brief was filed by Carrie Bogan, who was a co-founder of Lambda. He was one of the names on this ticket, I believe, of the corporation. And he was filing on behalf of the Gay Activists Alliance. They had a legal committee, which he was part of, and they backed him on filing an amicus brief. The Court of Appeals reversed the Second Department in a brief per curiam opinion that never uses the words homosexual or gay. And I went back and looked at it. preparing this, and I said, what's going on? You could read the entire opinion by the Court of Appeals, which is reproduced in your program, and not know what the case is about. They said, while appellant's status and past conduct may be now and has been in the past violative of accepted norms, they are not controlling, albeit relevant, in assessing character bearing on the right to practice law in this state. Notably, the Committee on Character and Fitness found appellant to be of good character and qualified at this time. With respect to the proceedings in the state of Florida, we accept the views expressed in the dissenting opinion of the appellate division. That's the entire opinion. So you read it and you say, what are they? They're afraid to say gay in New York reports, or homosexual, or something like that? Well, thank goodness we had a dissenting opinion by Judge Dominic Gabrielli, who goes on about homosexuality and immorality and deviant sexual intercourse at great length, so people reading the opinion will know what it's about and not be puzzled when the court refers to social norms. How did this guy deviate from social norms? Was, is he going out as he, cruel to animals? It was a puzzle. But, courts are like that sometimes. In fact, those of you who read my newsletter, Lesbian Gay Law Notes, will read, and you may have already seen it in ACD News, about a decision by the Second Department a few weeks ago in the first appellate ruling on transgender discrimination in the state of New York, which manages to write an opinion that never mentions it's about gender identity or transgender plaintiff or anything. I don't know. We still have some of the same judicial reticences sometimes. But Harris Kimball was admitted by order of the New York Court of Appeals. He went on to conduct a practice out of his office in Garrison, New York. He was a community-oriented practice. He did a lot of work for LGBT people and contributed a lot to his community as a leader. So today we celebrate the changing times, calmer heads, and this ruling, however timidly stated by the Court of Appeals, that ruled that openly gay lawyers who did not intend to refrain from having sex in violation of the Penal Code could be admitted to practice in the state of New York. I'm sure many lawyers out there in the closet gave a big sigh of relief and just burst, well, not quite, it took a while longer. But it laid the groundwork. It made it possible for organizations like Lambda, whose incorporation was allowed on the same date, and like our LGBT Bar Association, and like gay student groups suddenly getting organized in law schools because people knew that they could be admitted to practice if they were openly gay. Very important landmark. So once again, happy Pride, and hurrah for the Court of Appeals.
I'm Rachel Tibbin from Lambda Legal, and this is just a thrill. I mean, I have to say, what an honor and a delight it is to be able to hear some more of our history. And it is really with enormous pride and respect for the incredible people who got us to this point that I tell you that today Lambda Legal is more than 100 staff across 6 offices nationwide. With nearly 3 dozen practicing lawyers, we are the biggest LGBT legal department in the world. And our alumni include people like Evan Wolfson, Suzanne Goldberg, Alfonso David, and of course Raz Richter, and so many others. And it is incredibly gratifying to be arguing cases that cite precedent that we developed along with our siblings at the ACLU, GLAAD, the National Center for Lesbian Rights, Transgender Law Center, that we have built this remarkable body of law. And we continue to build on it still. And we have opportunities now to see it cited in other contexts. It's thrilling to see Romer versus Evans from 1996 cited in immigration cases for the principle that animus cannot be a legitimate basis for government action. Right? I mean, that's to really be able to see the work expand forward way beyond the contexts that we originally imagined. And it won't surprise you, having heard Bill Thom speak, that he continues to advise me and to cheerlead for Lambda in every way. And it's just an incredible honor and a privilege to know him, to know Nick, to know Michael Avery, and to really be able to carry that legacy forward. So in the interest of time, I'm not going to talk about all the wonderful cases we've won. You know many of them. Many of you participated in many of those cases. I'm just going to talk very briefly about the future. And the future really rests on two pillars. One pillar is protecting marriage equality and protecting what we have accomplished in reaching the apex of marriage equality in the Supreme Court decisions of 2013 and 2015, which stand not only for the equal legitimacy of our relationships, but our equal dignity as citizens before the law in every respect. Those are the crown jewels, and we will do everything to protect that achievement, and it cannot be chipped away at. One of the reasons that we are so concerned about the ruling in Masterpiece Cake Shop, although it is narrow, and although everything we do will be to work to keep it as narrow as possible, is that it suggests that there's maybe a different kind of marriage that LGBT people get. Right? Maybe there's a gay marriage, right? Evan crusaded so long to explain to the world that there is no gay marriage, right? There's only one kind of marriage. There's no skim milk marriage, there's no gay marriage, there's just marriage, absolutely identical and the same before the law for everyone. And so it is our obligation to prevent any cracks in that wall. And that's why what we will be doing from now on is protecting it by trying to hold Masterpiece and the religious exemption cases as narrowly as possible and to fight them with everything we have. Because it is our obligation, it is my obligation, that we will not be in a situation that might sound familiar to people who follow abortion rights very closely, where a person in a small town, in a rural area, cannot get married in their hometown because everybody there has a religious exemption and will not fill out their paperwork. And they can drive 3 or 4 hours to the nearest big city, and maybe there on every other Tuesday there's some nice lady who doesn't have a religious exemption who will fill out your paperwork. But if you want to go to the Social Security office and have your marriage recognized by the federal government, you'll have to cross state lines to do that. That is the dark future that Lambda Legal will fight against. And if that sounds fantastical, that is abortion rights today. So it is very, very possible to end up in a situation where the marquee cases remain in place, but underneath it's all hollowed out. And it is more hollowed out the poorer you are, the farther away you live from a big city, the fewer resources you have. If you are a couple who can't travel to marry, if you're parents who can't travel to find a pediatrician that will treat your family equally, if you can't simply change towns or change locations or change providers, when what you need is a tow truck by the side of the road in the middle of the night, or a hospital in an emergency. That's not something where you can just go buy your cake someplace else. And so preventing that kind of erosion is one pillar of what Lambda Legal is doing. And the other pillar is expanding the reach of sex discrimination law, which has been enormously fruitful and where we have won case after case after case with clear recognition from the Second Circuit Court of Appeals, the Seventh Circuit Court of Appeals, and in the employment context, and many, many courts in the context of schools, in Title VII and Title IX, where we have won fantastic decisions that say, of course it is sex discrimination. That to discriminate against someone because they are lesbian, gay, bisexual, or transgender is a form of sex discrimination, and we will continue to expand that court by court, state by state, circuit by circuit. And that is a patchwork quilt that will continue to protect us as we move forward. And lastly, I'm glad that Bill alluded to, in some ways, our proudest achievement, which is that we're not just a leading LGBT rights organization advocating for LGBT people and people living with HIV. We are a leading civil rights organization. And we play a role in a civil rights coalition that is really the opportunity to pay forward the extraordinary work that you heard described today. When we are in the Senate Judiciary Committee, arm in arm with the NAACP, with the Mexican American Legal Defense and Education Fund, with the Leadership Conference on Civil Rights, arguing against judges who are so biased, so homophobic, so racist, that they are not fit for a seat on the federal bench. And when Senator Feinstein holds up a letter in front of the Senate Judiciary Committee and says, according to Lambda Legal and 30 other civil rights organizations, you, sir, it's almost always sir, are not fit to be a judge. That is a kind of leadership, not only on behalf of LGBT people and people living with HIV, but all Americans and everyone who lives in this country. When the Muslim ban decision comes down, whether it's Thursday or whether it's next week, you will see Lambda Legal on the front lines with our Muslim brothers and sisters, because abuse of religion is a danger to all of us. And because it is our opportunity to say, not just that there are LGBT Muslims, of course there are LGBT everything, but because as civil rights advocates, abuse of the Constitution is wrong. And I think that perhaps it is for this incredibly dark and dangerous time that we have built this much power. Thank you all.
Thank you so much, Rachel. Our final speaker tonight is going to be Judge Michael Sonberg. He may be retired from the bench, but he is not retired from being the unofficial historian of LGBT judges in New York and elsewhere. And he's going to finish up Bill Thom's story for us. Judge Sonberg.
Thank you, Matt. Before I start, two things. First, I want to acknowledge three people who I consider my friends who are in the audience who I think are worthy of introduction. First, Judge Joseph Zayas, who is the Administrative Judge of Queens County Supreme Court criminal term. Second is Joyce Hartsfeld, who is the Executive Director of the Franklin K. Williams Commission on Minorities for the New York State court system. And the third is Barry Clark, who's in the back, who is OCA's Director of Operations, and has been an incredible supporter of diversity in this county, certainly in the 10 years I've worked with him, and I'm sure for long before that. One other thing before I start, which is sort of a coda to what Judge Feinman talked about in the work we do with the Hank Henry Fellows, which is those of us who are old look around and see reports of kids coming out in their preteens and their teens and say to ourselves, God, how life has become easy. And these kids don't know how easy they have it. Well, when you read these applications, you see that the there's still no instruction book that we give to young people to tell them how to come out. And some people are fortunate and have supportive families or know themselves well and are prepared to deal with what's still in some degree shame and embarrassment in most communities. And there are people who get thrown out of their homes, who have terrible times in coming out. And one of the things that we see in looking at these applications are the diversity of people's experiences, but that there's still, and I don't mean to suggest to the non-gay people who are here that they don't understand it, but you come to realize that you're different from everyone else in your family. And that's very difficult to deal with. And that's very difficult to get a handle on. And particularly if you come from a culture which suggests that this is the worst possible thing you could be, it's still a very tough road for kids to handle. So they all need all of our support and encouragement to come out when it's right for them. I still hear stories about people coming out in their 40s and 50s and 60s, because for some people that's when it first becomes available to them, when it first becomes right for them. So, on August 28th, 1984, New York City Mayor Edward I. Koch swore in William J. Thom as the judge of the Civil Court of the City of New York, making Judge Thom the first openly gay or lesbian person to be appointed or elected to a court established by the New York State Constitution. 34 years later, it's difficult to describe the excitement that caused, especially in New York's lesbian and gay legal community. Bill Thom wasn't just a lawyer who happened to be gay. Bill Thom, along with a precious few others of that time, was a very publicly out gay lawyer. If you were active in New York's small but growing lesbian and gay legal community in 1984, you knew Bill Thom, or at least who he was. That's because Bill Thom had been if not the, leading force in New York's gay legal community for more than a decade, starting at a time when you could count the openly lesbian and gay lawyers in New York on the fingers of your two hands. It wasn't real popular to be an openly lesbian or gay lawyer in the early 1970s. Let me give you a brief historical perspective. You've heard from Bill about the difficulties in getting Lambda recognized. You heard about Art with respect to Harris Kimball. Not surprisingly, and Bill made oblique reference to this, those weren't the first cases in which judicial homophobia raised its ugly head, only to be corrected through the appellate process. In 1970, the year after Stonewall, the Gay Activists Alliance submitted an application to be incorporated as a not-for-profit corporation with New York Secretary of State. It was rejected on two grounds: that the word gay was inappropriate for a corporate name, and that GAA sought to promote activities contrary to specific provisions of the penal law, namely those relating to consensual sodomy. When GAA went to Supreme Court in Albany County on an Article 78 proceeding, that court denied the petition, saying, "The troublesome posture of the petitioners is that by identifying themselves as a homosexual rights organization, they are professing a present or future intent to disobey a penal statute of the state of New York." Echoes of Kimball, this is pre-Kimball. While the court has no personal experience upon which to rely, it would seem that in order to be a homosexual, the prohibited act must have at some time been committed or at least presently contemplated. The Appellate Division, 3rd Department, unanimously reversed in March 1972, holding that the word gay was neither obscene nor vulgar, even though it is considered synonymous with homosexual, and that it was not unlawful for a group of individuals to peaceably agitate for the repeal of any law. The state appealed, which speaks volumes concerning government's attitudes, and the Court of Appeals affirmed in January 1973, only 9 days after hearing oral argument. Throughout that period, from the early 1970s until his appointment in 1984, Bill remained active and visible in the community and Lambda and in the profession. There was not a single lawyer in New York City in 1984 whose name meant gay rights more than Bill Thom's. Since Mayor Koch never publicly discussed the politics of Bill's appointment, we don't know the official explanation as to why it happened in 1984 and why it was Bill Thom. And I can tell you that as one of Mayor Giuliani's only 2 appointments of an openly gay judge in 8 years in office, that as much as curiosity might have made me wonder why me, the politic response was, "Thank you, sir." As for Bill's appointment, I can make an educated guess. California's Governor Jerry Brown, in his first incarnation as governor, had appointed the first openly gay judge in the United States, Judge Steve Lax, in 1979, and had appointed a lesbian and 3 other gay men before he left office in 1983. The ice having been broken, there was undoubtedly much pressure on Mayor Koch to appoint an openly gay man or lesbian to the bench. There was also significant displeasure with the mayor and the lesbian and gay community for having agreed to renew city contracts with the Roman Catholic Archdiocese, despite its refusal to sign the non-discrimination agreement required by an executive order the mayor had issued. Koch marched in the 1984 Pride March for the first time. He was heading towards running for a 3rd term in 1985. Bill had gone into the Democratic screening panel for a civil court seat in Manhattan, had been reported out, and was already running in the September 1984 primary, so Mayor Koch appointed him to fill the last 4 months of an interim vacancy on the civil court, letting Bill advertise himself as a sitting judge in the less than 2 weeks between his appointment and the primary. Unfortunately, it didn't work. Bill didn't win. Mayor Koch reappointed Bill to another interim vacancy for 1985. Bill ran again that year and lost in the primary again. Bill received 2 more interim vacancy appointments from Mayor Koch and served on the civil court through December 1987. Those of us who've had multiple interim appointments, I had 5 before my appointment to criminal court in 1995, know that they're not fun. After going through the process 4 times, Bill retired from the bench at the end of 1987. In the meantime, Mayor Koch had appointed Dick Failla to the criminal court in 1985, Mary Bednar to the family court in 1986, and Marcy Khan to the criminal court in 1987. After Bill's retirement from the bench in December 1987, he joined the Corporation Counsel's office, where he served through 1994, at which time he retired from practice. Thank you very much. Happy Pride.